February 14th, 2024, people. Today is the day that you should have your eyeballs watching the Vybz Kartel's case. Jamaican dance hall star Vybz Kartel on Wednesday, today, asked a London court to overturn his murder conviction, citing attempts to bribe his trial juror and the use of incriminating messages as reasons his conviction is unsafe. I just want to say great job to Asset Buchanan today and the rest of the team. I like the way you guys spoke. Your performance were on point. You could tell that you have been working this case and going through everything with a fine tooth comb, right? You definitely did your homework, and we're gonna see what's gonna happen next, right? Because tomorrow we go back to court, right, for this appeal hearing for Vybz Kartel, all happening in the UK. We're gonna jump right into it, folks. Soul Flow is gonna be bringing you up to speed on this one. So here we go. Vybz Kartel's appeal, February 14th in UK. Here we go.
Very possible. Freedom is looking very possible. Keep your fingers crossed. There were a lot of hiccups and mistakes made. There were a lot of law jargon and stuff that the average person wouldn't understand in this hearing at the Privy Council. But we're not attorneys, and worse, we're not British attorneys, and we don't have that thick British accent, so you really have to stress the listening for the most part to actually hear. Let's get into it. So, first of all, the link to watch it live, for those who don't know, will be posted as the first comment on this page, and it will leave the link. So just click the link and go watch it like the rest of us. If you didn't miss it, if you didn't watch it today, watch it tomorrow, right? At the Privy Council site, it says that Sean Campbell and 3 other appellants versus the King. They are listed as appellants. The King is listed as a respondent. Number 2 says Jamaica. And then there is information here where they basically give you the breakdown of what the case is at the Privy Council level. We have our whole thing already about where we've been talking about. But you need to know what's going to be argued in front of the Privy Council. So it goes like this. Issue. This is the issue. On the 13th of March 2014, the appellants were convicted of the murder of Clyde Blizzard Williams. The issue is that this appeal is whether their convictions are safe in light of the following grounds of challenge. 1. Should the trial judge have excluded the telecommunication evidence relied on by the prosecution? That's 1. 2. How should the judge have handled the allegations that there were attempts to bribe jury members during the trial? Should the jury or the particular juror said to have offered the bribe have been discharged? That part, stick around for that. 3. Was the judge wrong to invite the jury to reach a verdict late in the day, even given the special circumstances of this case? Now, it goes on further to say that these are the facts. After trial that lasted 64 days before the trial judge and a jury in the Home Circuit Court in Kingston, Jamaica, the appellants were convicted of Mr. Williams' murder. The prosecution's case was that the appellants murdered Mr. Williams on the 16th of August 2011 after he failed to return 2 licensed firearms which the second appellant, Mr. Palmer, had given him for safekeeping. Sean Storm is listed as the first appellant, not Vybz Kartel. Mr. Palmer had given him for safekeeping. Now, Mr. Williams was not seen or heard from after that date, and his body has never been found. The police took the appellants into custody on the 30th of September 2011 and seized their cell phones. The prosecution relied heavily on evidence that was derived from these cell phones, which was taken from a copy of an SD-ROM provided by Digicel, a telecommunication provider in Jamaica. In response to the police request at the trial, the appellants challenged the admissibility of this telecommunications evidence. They argued that the police request to Digicel and Digicel's provision of data to the police were actually carried out in breach of the Interception of Communication Act. You can go look up what that is. Further, the evidence had been obtained in breach of the fundamental rights to the protection of privacy of communication that was guaranteed by the Chapter of Fundamental Rights and Freedom obtained in the Jamaican Constitution. However, the trial judge ruled that the telecommunications evidence was still admissible even though it violated multiple rules within the Constitution. Right? It was said that it was brought to the judge's attention in Vybz Kartel case that there was a juror in there that was doing that. In a case like this, what they usually do is they usually get rid of that particular juror and replace them with somebody else, or they get rid of that entire jury pool because it's now tainted and bring in a fresh new set of people to serve. In this case, they kept the same person on the jury for the whole time. Now get this, this is the kicker. They kept him there for the whole time until the case done. He was a part of making the decision for Vybz Kartel to be sentenced to life or for Vybz Kartel to be free. No wonder it ended up 10-1. 10 decided, yes, send them to prison. One person held out. It was a 10-1 decision, right, in the case. Check this out. After that was done, the same juror was put on trial for the same offense and was found guilty and was given prison time. So if he was so guilty that he was found guilty and given prison time after the case was done, why was he left on the jury for the whole case? He should have been taken off, or that jury pool should have been done away with. You see what I'm saying? So there is just more mess and friggery that went on in this trial than anything else. Now tomorrow we'll stay close to it to see what's going on.